Hello, my name is Carl Isselhard. I am a business student in law, ethics, and social responsibility in Business 501, fall of 2017, Professor Frederick Green. This class is going to be taught today as one of the requirements for that class. And today we're going to be talking about alternative dispute resolution. There we go. Also known as ADR. Typically in business these days, specifically mine, I can tell you we just simply refer to it as ADR. So if you hear me say ADR, I'm simply talking about alternative dispute resolution. So today what we're going to be doing, we'll be defining ADR. We're going to discuss the reasons for ADR. There's a few of them. And we'll be identifying various different types of ADR and their processes. Lastly, we'll be discussing some of the potential ethical issues associated with ADR, which really pertains to this class. So alternative dispute resolution, simply defined, refers to a variety of processes that help parties resolve disputes without having to go to trial. Now you may ask why this is important. Well, trials are expensive, very expensive, and in fact, we'll skip to this slide here. This was done in 2013 as a simple comparison of some of the charges, some of the fees and costs associated with trials. I think this was a fairly conservative estimate. If we look here, let's say the employment section, they've got an estimate there close to $100,000 for a trial. I can tell you from past experience, I've been through a trial, an employment related case back in 2013, 2014, and that case itself was upwards, it was in the hundreds of thousands of dollars. So I think these are pretty conservative estimates, but nonetheless, I think it gets the point across. That trials are expensive. Secondly, it speeds up the settlement. So these trials are timely. They can last a year and a half by the time you get motions and your settlement meetings and conferences and trial dates and the change of trial dates. I can tell you the case I was involved with, that lasted for about a year and a half before we had a jury trial and everything was settled from start to finish. So when we say ADR speeds up the settlement, the parties involved typically aren't looking to get into a year and a half long battle with the other party. So the speed of the settlement and the timeliness of it is an added benefit that ADR can bring to the table. These are generally kept confidential. They're less formal and less stressful than court proceedings. Notice it says generally, so sometimes things are disclosed, sometimes they're not. The case I was involved with, we had some settlement conferences that were I guess far less formal and less stressful than the actual courtroom itself. You're still typically under oath, or you can be, but the proceedings themselves are in a much less threatening environment. The parties play a role which can lead to creative solutions, long-lasting outcomes, and improved relationships. So this benefit, the parties being involved in the actual settlement of the dispute, is like it says here, is a benefit because alternative creations, solutions can be thought of kind of on the fly. Going through this with my mother-in-law, she had a settlement conference when my father-in-law died, and some of the family wasn't happy with the will. So we had some settlement conferences. They came up with some creative solutions, I think, that probably would not have come up in the courtroom, such as, you take this RV and I'll take that, item, whatever the case may be. So they were able to negotiate through that which probably would not have happened in a courtroom to sit there and negotiate item by item and come up with creative solutions. So alternative dispute resolution does have some benefits there. So when we talk about alternative dispute resolution, there's two major forms, and we're going to talk about those mostly, the arbitration and the mediation. There are a ton of other forms, and I will touch on some of these as we go along. This list certainly is not all-inclusive, but it'll give you an idea of what we're talking about. So when we talk about the two major forms, like I said, arbitration and mediation, some of the other forms that we'll talk about are settlement conference, neutral evaluation, collaborative family law, parenting coordination, or PC, and summary judgment or jury, trials. So arbitration. This is when a neutral person called an arbitrator hears arguments and evidence from each side and then decides on the outcome. This can be voluntary or it can be mandatory. In binding arbitration, the parties agree to accept the arbitrator's decision as final, and there is generally no right to appeal. So again, it's called binding arbitration, but it's agreed ahead of time, and that's the key. You have to agree to this ahead of time. And we see these typically in labor law, construction, securities regulations. So just to give you an example, I work for the fire department. We have a contract with our labor union, and in there, as part of the disciplinary proceedings, there's a grievance process. And if somebody just, for example, gets a reprimand, they don't like that, they can appeal it to me, the fire chief, and if they don't like that opinion or my answer, then they can take it from there to arbitration. And it's in the contract that it is binding arbitration. So both parties, myself and the aggrieved employee, are going to sit down with the third party arbitrator, and we're both going to kind of give our side of the story. He's going to say what he did, I'm going to say what action I took, what it was based off of, things like that. And that third party arbitrator is going to come up with a final decision that both of us are going to abide by. From there is no appeals process. So like I said, it's popular in the labor law, in the labor unions, I should say. So the arbitration process, just kind of a brief overview. The case gets filed, and an arbitrator selection process. So for us, we use a national company that provides arbitrators. So there's really no, I guess, negotiation, if you will, as far as who the arbitrator is going to be. Sometimes there is, sometimes it's written in some of the rules or the contracts that both sides will have to agree on the arbitrator. In our case, it's assigned, or he or she is assigned. So there's a preliminary hearing and scheduling order. We go through a discovery process, there's hearings and mediation, and then we get to the arbitration hearing. So this way, with the discovery process, the arbitrator, when they show up, they've already got the background history, they've got some of the motions, they've got some of the arguments, they know what they're walking into. So the first time they hear from us isn't the first time they're hearing about the issue. Post-arbitration briefs, so once the arbitration is over, typically try to keep it around a 30-day for the arbitration briefs to be submitted. And then 30, 60, 90 days, depends on the arbitrator, we will get a final decision. So that's kind of a brief overview of what the arbitration process looks like with a third-party arbitrator. Switching over to mediation, this is the other major form that we're going to talk about. It is similar to arbitration in that a trained mediator discusses the dispute with the parties and assists them in reaching a settlement. So notice it says assist. The mediator is not there to make a final binding decision like an arbitrator is. It's a negotiation to try to reach a compromise. Uh, Different from arbitration, and the facilitator has no power to render a resolution to the conflict. So we're simply trying to work out our differences. We see these oftentimes in commercial transactions, personal injury, construction, workers' comp claims, divorce, and employment. So we see these kind of all over the place too. A lot of it says here, commercial transactions. So a lot of times when you sign up for things online or you buy something online, if you read the fine print, you will notice that a lot of times they will have a mediation clause if you have any differences or disputes with the companies. And so that's what it's talking about here. And so what does that process look like? You have the mediator here in the center. Serves as a neutral facilitator. So they're not taking sides, they're simply facilitating the conversation. They assist in the generation or clarification of options, summarizes and restates, and prioritizes the issue. So as a mediator, it's real important. Sometimes we can get really off into the weeds, if you will, on some of these conversations. So the mediator is going to kind of keep everybody on track, summarize and restate what the issues are, prioritize people's issues, and then moving on to enforces the ground rules. So when we sit down for mediations, one of the first things that the mediator will do is lay down some ground rules. I think that's very important when we get into some passionate or spirited debate, when people are looking for things that they want, when they feel that they've been wronged in some way, shape, or form. So laying down those ground rules, when one person's talking, nobody else talks. We don't talk over each other. We keep our emotions in check. We try to appreciate others' perspectives, things like that. So what else? Evaluates options and possible consequences. So the mediator is going to look at some of the options that come up in conversation and say, well, if that, then what about this? So they're trying to prevent future problems and future issues surfacing from some of the solutions that may seem appropriate at the time. Lastly, they're identifying areas of mutual interest, and this common ground is really where the compromise comes together. This is what they're really looking for. Where's our common ground? What can we come together on? What do we agree on? And this is where we're going to try to make our ground. So this is a brief overview of kind of what the mediator's role is in a mediation. So we'll talk about a few of the other ones. Those were the two biggies. A settlement conference. So a judge or judge's representative meets with the parties and their attorneys to try and settle some or all of the issues of the dispute before going to trial. Focuses on narrowing the issues of dispute and trying to come up with a settlement. The strengths and the weaknesses of the case are evaluated to help negotiate the settlement, and oftentimes they are mandated just before a case is set to go to trial. So the case I was involved in back in 2013, we went close to a year and a half going through motions and depositions and mandates, interrogatories, all these things. And right before we were set to go to trial, we actually had a mandatory settlement conference. The way that went was we come in, we sit down, and we're really, it's kind of the last ditch effort to try and prevent going to a trial. So we had a gentleman come in. I believe he was actually a retired judge, and that's what a lot of times you'll find your mediators, your arbitrators, they're retired federal judges, state judges, things like that. So he was a retired judge, came in and heard both sides, had read all of the arguments, had read all the discovery, and really it came down to, what is this case going to settle for? And we're talking dollar amounts. So this was a sexual harassment case. The female came in with a number in mind, and we came back with counteroffers. And so each side's really weighing the strength that they think they have in their case. If they go to trial, do they think they're going to win? Do they think they're going to lose? And the judge is there to basically give you a little bit of insight to, hey, I think you have some weaknesses in your case here. And so you have to evaluate that and say, okay, if we lose, what is this case going to be worth? If we win, what is this case worth? And really that's kind of the process throughout the day, is going back and forth saying strengths, weaknesses, what are we really willing to settle this case for, and what is the other party really willing to settle the case for. So in our case, we were unable to come to an agreement, so we were just too far apart in the number. And so our settlement conference didn't work, and we ended up going to a jury trial. Let's move on to collaborative family law. So this gives married couples a way to end their marriage without having to go to court. We hear a lot of times about marriages ending and nasty court cases and nasty divorces. This is kind of a lighter way to do this without having to go to court. Both individuals in the case maintain their own attorneys throughout the process. And at any point in that process, if either side decides to go to court, then both sides must get a new attorney. The original attorney cannot represent them in the court proceeding. So this motivates everyone involved to keep working on an agreement so as not to have to start all over. So as we know, attorneys are expensive. The last attorneys I was dealing with in the labor case or the sexual harassment case, they were in the $300 to $350 per hour range. So we're talking about a significant amount of money here. It doesn't take long to add up. So the fact that if this goes to pieces, you have to go get a new attorney, start all over, pay those retainer fees again. There's some motivation there to really keep this together, keep pushing forward, and keep working. It's not appropriate at all times. So for example, if one of the spouses cannot be located, obviously you can't have any kind of mediations or collaborative work together if the other party can't be found. The other time that really sticks out is when there's any kind of spousal abuse and domestic violence involved in the case. So obviously, if there's any kind of danger, anything like that looming, we don't want to put the two parties in the same room and try to negotiate something in that aspect. Neutral evaluation. This is another type of ADR where each side presents their case to an evaluator. Notice the different terms here. You have mediator, you have evaluator, you have arbitrator. Each one term is a little different, and the meaning's a little bit different. So here you have the evaluator. They give an opinion on the strengths and weaknesses of each side's arguments and evidence, and offers opinions on how they think the case might be resolved. So again, this isn't binding. This isn't any kind of mandated solution. They're simply there to give an opinion. Most appropriate when technical issues are involved or when the most significant challenge is determining damages. And by damages, we're talking monetary value. It's not appropriate when strong personal or emotional barriers exist between the parties. So if the two parties have just too many issues to sit there and negotiate to try and get along, to try and work something out, then neutral evaluation is really not a good option. And in fact, for that matter, the ADR process in general really needs the two parties to be there on their own will. Now, that's not always the case. Sometimes it's mandated, but for it to really come to fruition and to work, the two parties involved need to be there voluntarily and really wanting to work out the issues. Parenting coordination. So this is a child-focused process in which a trained and experienced mental health or legal professional called a parenting coordinator assists high-conflict parents to carry out parenting plan. The goal is to help parents resolve conflicts regarding their children in a timely manner and to promote safe, healthy, and meaningful child-parent relationships. So the goal here is when two parents just cannot get along, and it's not a good environment for the children to be in, but everybody's willing to put the children first, which is always appropriate. They're really trying to work out some differences to figure out what's best for the children. That's where the parenting coordinator comes into play. So they're going to look at both sides. They're going to hear both sides. They're going to determine which parent should have sole custody or 50-50 custody. They're going to make those determinations. They're going to look. They may involve other healthcare professionals to say, these children need counseling. These children need other forms of help. So it's another form of ADR. Summary jury trials. These are only in limited locations. These aren't throughout the country. I'm trying to remember where I found this one. I think it was actually in California that they have these. Each side presents its case in a shortened version to a jury. So there is a jury. It takes it a little bit beyond some of the other ADR steps in that there's a jury that they have to assemble. And the jury makes a decision, and it's advisory only. So they're getting the jury's version of what their answer is going to be, but at that time, it's only advisory. So each side uses this as an indication of what the potential outcome of a jury trial would be. If you're hearing it straight from the horse's mouth, then you probably ought to be, heeding the warning signs if they're telling you you don't have a case or you might lose. So the summary jury trial is simply trying to get an idea in a shortened version of what might happen if it goes to a full jury trial. So those were some of the bigger types of ADR. There's obviously, like I said, several other options out there. That list was not all inclusive, but I kind of wanted to give you an idea of what ADR looks like, other than the two major forms. This is a law, ethics, and social responsibility class, so I think I'd be remiss to not talk about a little bit of the ethical issues that can be associated with ADR. Conflicts of interest with mediator. This would be a big one. Must disclose all known and potential conflicts. So you don't want to go into a mediation and have the mediator favor one side or the other. It could be, maybe they're family friends, they know each other somehow, they played high school football together, they, whatever the case may be. If there's any kind of known or potential conflict, and we include the potential because even if that arbitrator or mediator were completely neutral, the perception is going to be that they were not fair if they don't disclose everything or simply remove themselves from the process. So we're really dealing with perceptions there at that point. Some of the biases. We don't want our mediators to have any bias. This would raise a big ethical issue with any form of ADR process. So they could be gender bias. Maybe it's a female that doesn't like males, a male that doesn't like females, whatever the case may be. This actually came up with a friend of mine who was going through a divorce and was going through a mediation, a form of ADR with the parenting. And he felt that the female mediator was favoring his ex-wife. Whether that's true or not, I don't know, but he certainly had the perception that it was true. So, right, wrong, or indifferent, there's not a whole lot you can do about that, other than, the mediator needs to make sure that they are neutral on their genders and not have any bias. Race biases, other biases, other personal reasons. Maybe they don't like the person. Maybe they don't like the way they look. Maybe maybe their nose is too big. Whatever the case may be, we just don't want to have any kind of biases because it will raise ethical issues with our ADR process. So the mediator must conduct the mediation impartially. I think that kind of goes without saying as far as what we've been talking about. They must have the necessary qualifications. Sometimes these mediations require some technical background, some technical knowledge. You may be talking about a sophisticated something that without the background history, the mediator is going to have a hard time trying to discern what to do with that case. Maintain confidentiality. We don't want our mediators to leave that room and go discuss things with other individuals. That's an ethical issue that the mediators must deal with. They need to ensure a quality process. Make sure that they do a good job. Make sure all the T's are crossed and the I's are dotted, and make sure that it's fair and equitable for everybody, and that it's that they reasonably expedite the process. So we're doing ADR as an alternative to a jury trial. So we talked about that in one of our first slides, was that speed was a benefit for the ADR process. So we want our arbitrators and our mediators to expedite this as much as they possibly can without jeopardizing the process. And we want to make sure the agreement reached is voluntary and uncoerced. So if there were some underlying ethical issues with our arbitrator, and they're really trying to push one party into something they don't want to do just to settle the case and say they got it settled, that's an ethical issue that they need to recognize, that they're there to facilitate and mediate and not force one side into something that they don't want to do. In response to some of the ethical issues that have been raised over the years, the American Bar Association came up with some model rules, standards, and policies to help facilitate that discussion and that ethical dilemma, if you will. So some of the model rules and standards, they call them model standards of conduct for mediators. There is the family mediation standards, the standards for establishment and operations of ombuds offices, the code of ethics for commercial arbitrators, the ethics codes for settlement negotiators. So these are all policies, manuals, standards that the American Bar Association has come out and published in an attempt to make the arbitrators, the mediators, aware of the ethical standards. Without anything published, we're really relying upon each individual's own ethical standards and their own moral values to do that. So this is an attempt to try and at least put everybody on a somewhat level playing field with some of their ethical standards. Some of their policies are resolving, promoting civil public discourse, and foreclosure mediation. The model standards of conduct for mediators, the code of ethics for arbitrators, the standards for the establishment and operation of the ombuds offices. So again, these are all some of the rules and the standards and the policies that the American Bar Association has published and come out and said, here are some rules to follow. Here are some standards to follow. So in summary, we have alternative dispute resolution, or ADR. This includes several processes that help parties resolve disputes without having to go to trial. Remember, the object here is to settle the dispute before you get to trial, to save that time, to save the money, to save it's less formal. You get greater satisfaction out of it. So it's just a different way to settle your disputes. Hopefully it's a little cheaper and a little more pleasant. The two main types were arbitration and mediation. Remember, the arbitration has an arbitrator. It can be binding. They're going to offer up they're going to give you the decision from the arbitrator. The mediation, or through the mediator, is there to simply negotiate, kind of help the two sides negotiate and navigate through that process. Some of the other forms we quickly talked about were the settlement conference, the neutral evaluation, collaborative family law, parenting coordination, and summary jury trials. And again, this list is not exhaustive. There are several other types of ADR. So I just wanted to give you a few examples of some of the other ones, other than the two main ones. Some of the ethical issues surrounding ADR, the biases, the potential issues could include them not being impartial, them not being qualified, and by them I'm talking about arbitrators, mediators. They not keeping it confidential, they don't expedite the process, or it's not voluntary and it is possibly coerced. So that's really kind of a summary of what we talked about. These are some of the references I used, and this PowerPoint will be available for anybody that would like to look at it. I appreciate your time. Again, my name is Carl Isselhard. This was for Business 501, and today's date's November 4th, 2017, and I appreciate your time. Thank you.